The morning it started, I was standing at my kitchen counter waiting for the coffee to drip through an old paper filter that always folded at the corners. It was a Tuesday, gray outside, the kind of cool spring morning when the window over the sink fogs a little at the edges. I remember the low hum of the refrigerator, the smell of coffee, and the way my phone lit up and buzzed once against the counter. When I picked it up, I saw my brother's name. I almost let it ring out. My brother, Daniel, does not call early unless something has already been decided without me. That had been true when we were in our 20s, and it was still true now. I answered anyway. He did not say hello. He said, very clearly, Dad filed in probate yesterday. He says you took money from Mom before she died. I stood there with the mug still empty in my hand. The coffee kept dripping, one slow drop at a time. I did not ask him to repeat it. I did not defend myself. I did not say the first 10 things that rose into my throat. I just looked out at the narrow strip of backyard behind my townhouse in Arlington and listened to a delivery truck backing up somewhere down the block. Then Daniel added, in a lower voice, "There's also a packet here from a bank. Dad hasn't opened it yet." That was the only part that made me set the mug down. I asked him when the hearing was. "Next Thursday," he said. "Fairview County Courthouse. 10 a.m. I thanked him. I hung up. I turned off the coffee maker before it finished its cycle. Then I stood in the quiet for a few seconds with one hand flat on the counter, looking at my own reflection in the dark microwave door. At 42, I had learned that shock does not always feel sharp. Sometimes it feels administrative. A list forming in your mind. A drawer opening. A clock starting. I carried my coffee to the dining table and sat down in the same chair where I paid bills and signed contracts and sorted the practical parts of my life. My townhouse was small, neat, and usually very still in the mornings. There was a wool runner under the table, a stack of unopened mail by the lamp, and a ceramic bowl near the window where I dropped my keys every night. Everything was where I had left it. That steadiness helped. My father had always believed that if something could not be seen, it probably did not exist. If work was real, it came with dirt on your boots or a name on a building. If sacrifice was real, it happened in front of witnesses. If love was real, it stayed close to home. I had been gone from home for 14 years. Not gone in the dramatic sense. I still sent flowers on birthdays. I still called my mother every Sunday evening unless I was traveling. I still paid for things quietly when I knew she would never ask. A stair rail, a heating repair, a medication copay she tried to describe as nothing much. But I lived outside Richmond now, and I worked in a field my father never respected because he could not reduce it to a simple sentence for people at church or at the farm supply store. To him, my life had always sounded suspiciously tidy. He liked visible work, trucks, fences, receipts written in thick blue ink. My work existed in secure buildings, restricted systems, and calendars that never told the whole story. Over the years, he had turned that gap into a character flaw. I should say this plainly. My father was not a loud man all the time. That would have been easier. He was controlled in public, thoughtful when people were watching, the kind of man who held doors, chaired committees, and remembered names. He served on the county planning board for years and carried himself like someone who expected the room to arrange itself around him. At home, that same calm had edges. He could make a judgment sound like common sense. He could take a guess and speak it as fact. And once he decided who you were, he saw every small thing as proof. My mother knew that. She moved around him carefully in the last few years, especially after her memory began to slip in uneven ways. Not dramatic at first, just small losses, missed appointments, repeated stories, a pan left warming on the stove without anything in it. By the time the doctors gave it a name, I had already started keeping notes after our calls. Dates, medications, bills she mentioned, names of specialists. Then I started paying attention to her checking account, not because I distrusted her, because I had begun to distrust the silence around her. That Tuesday morning, after Daniel's call, I pulled my laptop toward me and opened 3 folders I had not touched since the funeral. The house was still dim, the kind of dim that makes a screen feel brighter than it is. I could hear a neighbor rolling a trash bin down the sidewalk. Somewhere upstairs, the heat clicked on. The first folder held copies of wire transfers, invoices, and home care payments. The second held messages. The third held scanned documents, including one envelope I had photographed before placing it in my safe 2 months earlier. My mother had given it to me during one of her clearer afternoons. She was sitting by the den window with a blanket over her knees and a cup of tea she kept forgetting to drink. She had touched my hand once, lightly, and told me not to argue with anyone until I had to. I had not opened that envelope since. I looked at the image now for a long moment. Then I took one sip of coffee. It had already gone lukewarm. Step 1, I told myself, was simple: pull every record. Step 2, build the timeline. Step 3, say only what could be proved. I put my phone face down. Then I waited for the bank portal to load. The bank portal took longer than usual. I sat there listening to the faint whir of my laptop fan and the soft tapping of a branch against the window over the table. My coffee had gone completely flat by then, but I drank it anyway. I did not want to get up. I wanted everything in one place before the day started moving. My mother died in late January. The hearing had been set for April. In between those dates, my father had done what he always did when he wanted control. He moved quickly, spoke first, and filled the silence before anyone else could. By the time I received the formal notice from the court later that afternoon, I could already hear his version of me inside the language. Daughter residing out of county. Irregular financial involvement. Questionable withdrawals. Failure to provide consistent care. It was written in careful legal phrasing, but his voice sat underneath every line. I printed it, placed it on the right side of the table, and began laying out my own papers to the left. Statements first, then payment confirmations, then the private caregiver invoices, then the emails from the neurology office, the pharmacy receipts, the transfer records for the rehab equipment, and the notes I had kept after phone calls with my mother during the last 18 months of her life. When I work through a problem, I like visible order. Not for appearance, for sequence. By 11 o'clock, the table looked less like a dining table and more like a records room. The sunlight had shifted farther across the floor. I could smell warm paper from the printer and the faint detergent scent from the clean dish towel hanging over the sink. I found the first transfer my father would probably question. $6,000. Early March of the previous year. I clipped it to the invoice for overnight nursing coverage after my mother's fall in the hallway. Then another one. $3,420. April. That matched a bill for in-home physical therapy visits and a stair safety assessment my father had insisted was unnecessary until my mother slipped a second time. Then another. $1,872 for medication, glucose sensors, and 2 weeks of prepared meals, all charged to my card and reimbursed later from my mother's account after she told me, in one of her firmer moments, that she would not be kept like a child. That was the thing about the story my father was building. It depended on distance looking like neglect. It depended on the fact that I was not there every day in person, that I lived 90 minutes away, that my job required long stretches of silence and missed calls and rescheduled weekends. From the outside, that kind of life can be made to look cold very easily. But records tell a different story if you let them sit long enough. I called in-home care agencies when he refused to. I paid deposits when services could not wait. I handled insurance appeals my father found insulting. I spoke with pharmacists, claims managers, discharge coordinators, and 3 separate neurologists. I ordered bathroom rails, arranged respite coverage, tracked medication reactions, and moved money where it needed to go when timing mattered more than pride. Most of that work leaves no obvious mark. It does not stand in a field or hang on a wall. It happens in hold music, portals, confirmations, and calendars. My father had no patience for that kind of work because it did not let him remain the central figure. My younger sister, Lauren, had learned to stay near him, which in our family often passed for loyalty. She lived 20 minutes from my parents' house in a newer subdivision outside town and came by often enough to be seen doing so. That mattered to him more than whether the bills were actually paid or whether our mother's care plan made sense. Lauren was 36 then, pleasant in company, careful with her expressions, and very good at stepping into a room at exactly the moment sympathy was available. She was not cruel in a loud way. She was practical about advantage. If my father had decided I was the difficult daughter, Lauren knew not to interrupt the arrangement. Around noon, she texted me for the first time in 3 weeks. I heard the vibration against the table and looked down at the screen. I hope you're not planning to make this uglier than it already is. I read it once. Then again. No greeting. No question. No mention of our mother. I set the phone down without answering and went back to the statements. At 1:30, I called the bank branch in Fairview, where my mother had kept her personal checking account for years. The woman who answered had a patient, practiced voice, and I could hear the muffled sounds of a lobby behind her. Printers. A door buzzer. Someone laughing too loudly at something routine. I gave my name. There was a pause, and then her tone changed just slightly. "Yes, Ms. Mercer," she said. "I remember you." That mattered. I asked whether the packet referenced in the probate filing had been generated automatically or requested. "Requested," she said. "By whom?" Another pause. Paper moving. "Your father requested certified copies of selected withdrawals and signature cards after your mother's estate account was opened." Selected withdrawals. Not all activity. Only chosen items. That was exactly his style. He never lied when omission would do the job more elegantly. I asked whether the branch still had appointment logs from the dates of the withdrawals in question. She said they did, though anything formal would need to go through counsel. I thanked her and wrote it down. Then I asked one more question. "Do your branch notes indicate whether my mother came in person for those transactions?" The answer was careful. For at least 2 of them, no. One was handled through prior authorization already on file. Another involved reimbursement documentation submitted at the desk. Reimbursement documentation. I closed my eyes for a second and wrote the phrase down exactly. That was the first real shift. Small, but real. Up to that point, I had been collecting facts. Now I had process. And process is harder to bend. By late afternoon, I had built a full chronology across 14 months. Calls, invoices, transfers, appointments, medication changes, memory testing, caregiver schedules, home modifications, insurance disputes. I color-coded the pages with tabs I found in my desk drawer. Blue for payments, yellow for medical, green for communications, red for anything that had been left out or selectively framed in the probate notice. When I finally stood up, my back ached a little from sitting too long. I carried the empty mug to the sink, rinsed it, and looked out the window again. The sky had cleared. Across the fence line, somebody was grilling early, and I could smell smoke and sweet bottled sauce drifting lightly through the screen. That ordinary smell almost undid me. Not because I wanted to cry. I didn't. Because grief is strange when administration gets poured over it. You are trying to prove that your care existed while also accepting that the person you cared for is gone. There is no clean line between those 2 things. Just paperwork. Timestamps. A cardigan still hanging on the back of a chair in a house that now belongs to memory and argument. I dried my hands and went upstairs to the hall closet where I kept a small fireproof safe on the top shelf behind extra blankets. Inside were passports, old tax records, the deed to the townhouse, and the envelope my mother had handed me in January. It was cream-colored, slightly bent at one corner, with my name written on the front in her neat, deliberate handwriting from before the tremor in her fingers got worse. Not a dramatic note. Not a final speech. Just my name. I brought it downstairs and placed it in the center of the table without opening it. The room was quiet by then. The light had gone softer, and the edges of the papers looked almost gold where the sun hit them. I sat down and rested both hands flat on either side of the envelope. There are moments when opening something feels less like curiosity and more like crossing a line. I stayed there for a while, listening to the clock above the stove. Then I opened it with a letter opener and slid out 3 pages. The first was handwritten. The second was a copy of an instruction letter to her estate attorney. The third was a list of payments, dates, and names in my mother's own hand, including mine. At the bottom of the first page, she had written one sentence I read 3 times before setting it down. Not because it was emotional, because it was precise, and because it changed the shape of the hearing completely. Then I reached for my phone and called an attorney I had not spoken to in almost 6 years. The attorney's name was Michael Renner. Years earlier, he had helped me with a property issue that crossed county lines and involved more paperwork than conflict. He was steady, exact, and not easily impressed by personalities. That was what I wanted now. Someone who would notice sequence before story. He answered on the third ring. I told him my name, and there was a brief pause before he said, "It has been a while." "It has," I said. "I need representation for a probate hearing next Thursday. There may also be a defamation issue developing alongside it." His tone sharpened, but only slightly. "Can you come in tomorrow morning?" "I can. Bring everything." That was all. The next day, I drove to his office in Richmond under a pale sky that looked like rain but never quite followed through. Traffic was slow near the river, and I remember the sound of tires on damp pavement and the warmth from the seat heater against the back of my coat. I had packed 2 document boxes in the trunk and the envelope from my mother in a leather folder on the passenger seat. Michael's office was on the second floor of an old brick building with narrow stairs and polished wood floors that creaked in a familiar way. His receptionist offered coffee. I declined. I wanted my hands steady and empty. When he came out to meet me, he looked almost the same. Gray at the temples now. Dark suit. Reading glasses hanging from one hand. He shook mine once, then glanced down at the boxes. "You weren't exaggerating," he said. "I try not to." Inside his office, the blinds were half open, and the room smelled faintly of paper, lemon polish, and the kind of coffee lawyers seem to forget on side tables. I laid everything out the way I had arranged it at home. Timeline first, then transfers, then medical records, then emails, then the handwritten letter from my mother. Michael did not interrupt while I spoke. That is a useful quality in an attorney. Some people listen for openings. He listened for structure. I walked him through it in order. My mother's diagnosis, the home care expenses, the reimbursements, the way my father had resisted outside help but accepted the results when a crisis had already passed, Lauren's selective involvement, the bank branch notes, the probate complaint and its wording. Then I handed him the handwritten letter. He read it once slowly, then leaned back in his chair and read it again. The rain finally started against the windows, a light, clean tapping that softened the street sounds below. He placed the letter on the desk between us and folded his glasses. "All right," he said. "This is no longer just about defending against their accusation." "No," I said. He tapped the page once with one finger. "This gives us intent. It also gives us instruction from your mother contemporaneous to the transactions. Combined with the reimbursement list and bank records, this is strong." Strong was not a word I reached for emotionally, but it mattered. He spent the next hour separating what would be useful from what would simply be satisfying. That distinction matters more than people think. In private, a person can be as angry as they need to be. In court, anger is often just wasted motion. He made 3 piles. The first was proof of payment and reimbursement. The second was proof of my mother's understanding and direction. The third was proof that my father had omitted material facts when filing. Then he looked up and said, "We're going to keep this narrow." I nodded. He took out a legal pad. "Step 1, he said, writing as he spoke. We answer the allegation with documentary evidence. Not opinion. Not family history. Evidence." He wrote another line. "Step 2, we establish that several challenged withdrawals were reimbursements for care expenses advanced by you." Another line. "Step 3, if your father or sister overstate, speculate, or imply incapacity beyond the medical record, we use the timeline and your mother's written instructions to show selective framing." He turned the pad slightly so I could see it. "Step 4, he said, only if necessary, we raise sanctions and reserve the right to pursue defamation." I looked at the page for a few seconds. That was the moment the whole thing stopped feeling like an ambush and started feeling like a process. Not because I trusted the court to be fair in some broad moral sense. Courts are still rooms run by people. But process has shape. It can be followed. It can be checked. It has edges. Michael asked me a number of questions I appreciated precisely because they were not comforting. Did you ever sign on your mother's behalf? No. Did you ever move money without her knowledge? No. Did she ever reimburse you in cash or through a third party? No. Only through her account or personal checks. Did you keep invoices at the time or reconstruct them later? At the time. He nodded each time and made a note. Then he asked, was there anyone outside the family who can speak to your role during your mother's illness? Yes, I said. 2 care coordinators. 1 private nurse. Her neurologist's office, though they may limit what they'll say. And the bank manager may remember me. Good. He wrote those names down too. When I left his office just after noon, the rain had stopped. The sidewalks were dark and damp, and the air smelled like wet concrete and spring leaves. I stood under the awning for a moment before walking to my car. Michael had the original letter in a protective sleeve and copies of everything else. He told me he would issue document requests that afternoon and prepare a response packet by Monday. He also told me not to contact my father or sister directly. That includes answering texts designed to provoke you, he said. That won't be difficult, I told him. He gave me a brief look over his glasses. It usually is. By Friday evening, the first requests had already started working. The bank responded through counsel with appointment notes and transaction records. 2 of the challenged withdrawals were attached to reimbursement forms submitted with invoices. One included my mother's written notation for Linda's overnight care and pharmacy pickup. Reimburse Claire. Claire was the name I am using here instead of my own. Small changes are easier on everyone. Michael forwarded the scanned copy to me just before 6. I was at home when the email came in, sitting on the floor in the den with a storage box open beside me. I had been sorting my mother's things that had ended up with me after the funeral. A silk scarf. A recipe tin with cards worn soft at the edges. A framed photo of the 2 of us at a garden center, both of us squinting in bright sun. I read the email once, then set the phone down on the rug. Then I waited. Not because I needed drama. Because there is a kind of relief that moves slowly when you have spent months being quietly misread. It does not arrive all at once. It comes in pieces. A line from a bank log. A date that matches. A note in your mother's handwriting that survived the noise around it. On Saturday, Lauren called. I let it ring twice before answering. Her voice was soft in that deliberate way people use when they want to sound reasonable before making something unreasonable seem necessary. I heard you hired a lawyer, she said. Yes. There was a short silence. You really want to do this publicly? I'm responding to what was filed publicly. That's not what I meant. I stood up and walked to the window. Outside, someone was walking a golden retriever past the row of townhouses. The dog stopped every few feet, as if the afternoon contained important private news. Lauren lowered her voice. Dad is upset. He thinks this can still be handled quietly if you don't force things. I looked out at the sidewalk and said, he filed a court action accusing me of taking money from our mother. You know why he did that? No, I said. I know the explanation he prefers. She exhaled through her nose, a small sign of irritation she had never quite grown out of. Claire, you were never around in a way people could see. It was such a familiar sentence that it almost sounded old before she finished saying it. I rested one hand on the window frame. That may be true, I said. It isn't the same as not being there. Another silence. Then she said, Mom was confused near the end. Yes. So you have to admit some of this may have looked wrong. Looked wrong to whom? She did not answer that. Instead, she shifted. Dad found records he didn't understand. And instead of asking for context, he accused me of theft. He thinks he was protecting the estate. The interesting thing about family disputes is how often people use the language of duty to cover the shape of something else. Control, embarrassment, resentment, fear. Those motives rarely introduce themselves honestly. I said, Lauren, there are documents. There are dates. There are invoices. There is also a letter from Mom. She went quiet so quickly I could hear that sentence land. What letter? I did not answer. Claire, she said again, less steady now. What letter? The kind that should have made this filing unnecessary. Her breathing changed. Just slightly. That was the second shift. Not a victory. I am careful with that word. Just a reordering of the room, even from a distance. She knew then that the version of events my father had assembled was incomplete. Maybe she had known all along in the way people do when they keep stepping around a fact because it is inconvenient. But now she knew I could prove it. She asked if we could meet before the hearing. I told her no. Then I ended the call, set the phone face down on the console table by the front door, and went back to the box on the den floor. There was a folded grocery list in my mother's handwriting tucked inside the recipe tin. Tea, lemons, soup, tape, birdseed, normal things. I sat there with that list in my hand for a long time. Outside, a car door slammed. A child laughed somewhere down the block. The house settled around me with its usual small sounds. On Monday morning, Michael sent me the draft response filing. Attached to it was a short note. They've overreached. We stay calm. We stay narrow. Also, there's one more item you should know before Thursday. I read that line once. Then I opened the second attachment and saw the name of the witness my father intended to bring. The witness was my father's pastor. Not because he had handled finances. Not because he had ever spoken with my mother's doctors, reviewed invoices, or visited the bank with her. He was being brought in, as far as Michael and I could tell, to establish character. Mine, mostly. Distance. Coldness. A lack of visible devotion that could be arranged to look like motive. I sat at my desk and read the notice twice. Then I closed the file and looked out the window for a minute. It had started raining again, just lightly. The kind of rain that blurs parked cars and softens the edges of everything beyond the glass. My office at home was small. Desk, lamp, one bookshelf, a narrow filing cabinet. Quiet enough that I could hear the rain tap the gutter outside. Michael called an hour later. I thought you should see that before court, he said. I'm glad I did. He can testify to what he observed personally, Michael said. He cannot testify to financial conclusions he is not qualified to make. He also cannot turn the hearing into a sermon if the judge is doing his job. I smiled a little at that. Still, he said, it tells us something. That they know the records are weak. Exactly. That was what mattered. When people have the documents, they usually rely on the documents. When they do not, they start arranging atmosphere. Michael and I spent most of Monday refining the response packet and deciding what would actually go into the room. Not every true thing belongs in court. That sounds strange to people who have never had to defend themselves in a formal setting, but it is true. The question is never whether you know more. The question is whether the additional information serves the narrow issue before the court. We kept returning to the same principle. Less emotion, more sequence. By Tuesday afternoon, I had a legal pad on my desk with my own version of the plan written in black ink. Step 1, let them speak first. Step 2, do not interrupt any exaggeration unless Michael tells me to. Step 3, answer only the question asked. Step 4, if documents are referenced incorrectly, direct attention back to the actual page, date, and amount. Step 5, no family history unless required to explain a record. Step 6, silence is not surrender. I left that page on the desk where I could see it. That week had a strange rhythm to it. On the surface, life remained ordinary. I took calls. I answered work emails. I picked up groceries. I dropped off 2 blouses at the cleaner. I made soup one night because the weather stayed damp and I wanted something warm that took very little thought. In between those normal things, I prepared to sit in a courtroom while my father tried to reduce my care for our mother to a pattern of suspicious withdrawals. There is no graceful way to describe how tiring that is. On Wednesday morning, Michael sent me the branch manager's formal statement. It was brief, clean, better than I expected. It confirmed that my mother had discussed reimbursements for home care and medical expenses in person with branch staff on more than one occasion. It also confirmed that supporting invoices had been presented with at least some of the disputed withdrawals. No opinions. No flourish. Just process. I printed it immediately and slid it into the binder under the tab marked bank. 20 minutes later, another email came in. This one from the private nurse who had covered several overnight shifts after my mother's second fall. She had attached copies of invoices and a short statement verifying that I had been the family contact for scheduling and payment. Again, not emotional, just useful. By that point, the center of the case had changed completely. My father had filed as if the issue were hidden misconduct. What we now had was a documented pattern of reimbursement and care coordination. He had mistaken a paper trail he did not understand for one that would support him. Or maybe he had understood enough and assumed no one would challenge him. Both happen. That evening, Daniel called. He had been careful all week, keeping some distance from the filing without defending it. He and I had never been especially close, but he was the least theatrical member of the family, and that counts for something. "Are you home?" he asked. "Yes, I'm outside." I looked through the front window and saw his truck at the curb. When I opened the door, the air smelled damp and cold, with the sharp, clean scent that comes after a full day of rain. Daniel was standing on the porch in a canvas jacket, holding a flat document box under one arm. He looked tired. He always looked slightly tired, even when he was in a good mood, but this was different, more deliberate. "I can stay 5 minutes," he said. "That's plenty." I led him to the dining table. The binders were stacked at one end now, neat and labeled. He noticed them and looked away from them just as quickly. "This was in Dad's study," he said, setting the box down. "I found it when I stopped by to fix the porch light. I didn't open it right away." "What is it?" He gave a small shrug. "Copies of things. Notes." I didn't read all of it. That answer told me he had read enough. I opened the lid. Inside were photocopies of selected bank statements, printouts of text messages with my name highlighted, and handwritten notes in my father's blocky penmanship. Dates circled, arrows in the margins. A few words underlined so hard the paper had nearly torn. One note read, "Ask why reimbursements were not discussed with family." Another, "No regular local presence equals no actual caregiving." And another, "Use pastor if needed. Community sees everything." I looked at the page for a few seconds and then put it back in the box. Daniel stood by the chair, hands in his jacket pockets. "He's been working on this longer than I realized," he said. I assumed he had. He nodded once. Then he said, without quite meeting my eyes, "Mom talked about you more than he lets on." That was the closest either of us had come to saying anything direct about grief. I pulled out a chair for him, but he didn't sit. "He thinks you made him look foolish," Daniel said. "In front of whom?" He gave a tired half smile. "That's always the question, isn't it?" Yes, it was. For my father, reputation was never abstract. It lived in rooms, church halls, feed stores, funeral lines, county meetings, back pew conversations after service. He did not simply want control over the estate. He wanted the public version of the family to remain arranged in a way that kept him at the center of competence and morality. A daughter with a documented record of quietly handling care, payments, and coordination did not fit that arrangement if he had already told people I was absent and self-interested. Daniel looked toward the box again. "There's one more thing," he said. "He thinks the judge will be sympathetic." "Why?" "He served on that courthouse budget committee with him years ago. They know each other." That was useful, though not necessarily in the way my father imagined. Familiarity in a county can make people bold. It can also make overconfidence look even worse. "Thank you," I said. Daniel nodded. Then he reached into his jacket pocket and set a folded index card on the table. "Mom gave me this in December," he said. "Told me to hold on to it in case things got difficult." He said the last phrase very flatly, as if it embarrassed him a little to quote it. After he left, I unfolded the card. It was my mother's handwriting again. Just 3 lines. Simple. Specific. She had listed the names of 2 people she trusted regarding her care expenses. Mine was first. The second was the bank manager. At the bottom she had written, "Your father does not like not being informed." That is different from not being cared for. I sat back in the chair and read that once more. That sentence did not need interpretation. It was as close to a direct correction as my mother was ever likely to write about him. Calm. Accurate. Final. I scanned the card and sent it to Michael immediately. He called within 15 minutes. "Well," he said, After a short silence, that's exceptionally helpful. I thought so. We may not even need to introduce it unless they force the issue, he said. But if they create the impression that there was confusion around who was handling care, this closes that gap. Outside, a car passed slowly through the rain-dark street. Its headlights moved across the ceiling for a second and were gone. Michael lowered his voice slightly, not for secrecy, just focus. Claire, listen carefully. By tomorrow morning, this is no longer a family argument. It is a records hearing with a family story wrapped around it. Don't let them reverse those categories. I won't. If the pastor speaks, let him. If your father tries to perform certainty, let him. The more they rely on memory and image, the more we rely on dates and process. After we hung up, I stood at the kitchen counter and made tea. Boil water. Warm the mug. One bag, then another because I wanted it stronger. Wait the extra minute. Add nothing. That small sequence helped settle my mind. I carried the tea to the table and reviewed the binder one last time. Branch statement. Caregiver invoices. Reimbursement list. My mother's letter. The instruction to counsel. The index card. The selected omissions in my father's filing. The notes Daniel had brought over, now clipped separately in case Michael decided they mattered. By 9:30, everything was ready. I laid out my cloaks for the next morning on the chair in my bedroom. Navy suit, white blouse, low heels. Nothing memorable. Nothing that asked to be noticed. Then I set my alarm, washed my face, and turned off the hallway light. In bed, the house felt especially quiet. I could hear the refrigerator downstairs, the faint ticking of the bathroom vent, the soft weight of rain easing off outside. My phone buzzed once on the nightstand. A text from Lauren. Dad says if you care about Mom's memory, you'll keep this respectful tomorrow. I looked at the screen for a few seconds. Then I turned the phone over and switched off the lamp. The room went dark. And in that darkness, with the hearing less than 12 hours away, I did the only thing left to do. I went through the order again in my head. Let them speak. Wait. Then answer with the page. I left the house before 7. The rain had stopped overnight, but the pavement was still dark and damp, and the air had that washed, early morning smell that always reminds me of school drop-offs and office parking lots. I drove with the radio off. The binder was in the passenger seat beside my bag, and every so often I would rest my hand lightly on the cover at a red light, just to make sure it was still there. By the time I reached Fairview County, the sky had started to brighten in a pale, even way. Not sunny, just clear enough to flatten everything. The courthouse sat where it always had, square and self-important, with brick steps, white columns, and a flag moving only slightly above the entrance. I parked across the street and sat in the car for a moment before getting out. People think courage feels active. Sometimes it feels like opening a car door when your body would prefer another 10 minutes of stillness. I took my bag, the binder, and crossed the street. Inside, the courthouse smelled the same way it had years ago when I came for my first permit hearing with the landlord. Old paper, floor polish, coffee from somewhere too weak to identify. The security tray rattled as I set down my phone and keys. The deputy at the scanner nodded at me without curiosity. That helped. Michael was already there when I reached the second-floor hallway. He stood near a long wooden bench under a bulletin board crowded with notices no one seemed to read. Dark suit, blue tie, coffee in one hand, legal folder in the other. You're early, he said. So are you. That's how I stay calm. I almost smiled. He took the binder from me and opened it briefly, checking the tabs, though he already knew what was inside. That, too, was part of his way of staying calm. Touch the order. Confirm the sequence. Reduce surprises where possible. He handed it back. We're in Courtroom 3. Judge Holloway. Not the judge my father expected, I said. Michael's eyes lifted slightly. No. Reassignment at the last minute. That mattered. Not because I believed another judge would be automatically fairer, but it removed the advantage of familiarity my father had apparently been counting on. Whatever happened now would happen in a room that belonged more to procedure than local comfort. We went in 10 minutes later. Courtroom 3 was smaller than I remembered from years ago. Dark wood, narrow windows, old brass lamps mounted along the wall. The overhead lights were on, but the room still carried a muted kind of morning dimness. I could hear the vent system humming lightly above us, and somewhere behind me a chair leg dragged once against the floor. My father was already seated at the plaintiff's table with his attorney, Douglas Pike. He looked over as I entered and held my gaze just long enough to make the gesture intentional. He was wearing the same expression he always wore when he wanted a room to know he considered himself the reasonable party. Controlled mouth. Slight lift of the chin. Not anger. Offense. Lauren sat in the second row behind him in a light beige jacket, hands folded around her purse strap. When she saw me, her face changed for a second. Not guilt exactly. More like discomfort at seeing someone arrive better prepared than expected. The pastor was there too. Front row on the aisle, Bible-thin folder in his lap, shoulders set very carefully. I took my seat beside Michael and placed my hands flat on the table. Then I waited. When Judge Holloway entered, everyone rose. He was a man in his 60s, spare, quiet, with a kind of expression that revealed almost nothing until someone wasted his time. He sat, adjusted his glasses once, and began with the calendar in a tone that made it clear he was not there to observe family dynamics. He was there to move through issues one by one. That helped too. The case was called. Appearances were entered. Then Douglas Pike stood. He had a smooth, practiced voice, and he used it the way some people use polished furniture, to create an impression of care without inviting scrutiny. He began by framing the matter as a tragic but necessary dispute over accountability. A daughter living away. A grieving husband. Financial irregularities discovered after death. A need for the estate to protect itself against improper withdrawals. He did not raise his voice. He did not need to. He was speaking to a judge, not a crowd, and he understood that. But the shape of his case was the same one my father had been building for months. I was distant, intermittent, difficult to verify. My involvement with my mother's care was self-described. My reimbursements were unsupported or inconsistently documented. My access to my mother's accounts and his phrasing coincided with a period of cognitive decline. He was careful. But careful people still leave seams. Michael made only a few notes while Pike spoke. I watched the judge instead. No visible reaction. Just listening. Then Pike called my father. My father was sworn in and sat down in the witness chair with the stiff dignity of a man who still believed his certainty would carry him farther than any document. He testified that my mother had become vulnerable near the end, that I had appeared only occasionally, that I claimed to be handling things remotely, and that after her death he found withdrawals he could not explain. Pike asked him whether he had raised concerns with me directly. My father said yes. That was not true in any meaningful sense. He had raised suspicions, not questions. Pike asked whether he had ever received clear records from me while my mother was alive. My father said no. Also not true, though I understood why he preferred it. Then Pike asked the question that revealed the whole strategy. In your observation, Mr. Mercer, who is the family member most consistently present for your wife's day-to-day needs? He did not say who paid, who scheduled, who coordinated, who handled insurers. He said present. My father answered as expected. Lauren. There it was. Presence as performance. Visibility as virtue. Pike let that settle in the room. Then Michael stood for cross-examination. His manner did not change at all. No indignation. No edge. He took a yellow pad with him to the podium and began as if he were clarifying a contract. Mr. Mercer, he said, you testified that you found withdrawals you could not explain. I want to look at the March 7th transaction in the amount of $6,000. Do you have that in front of you? My father adjusted the papers. Yes. You consider that suspicious? Yes. Michael nodded once. Turned to the exhibit directly behind it. The invoice from the overnight nursing service. Same week. Similar amount. Have you reviewed that before today? My father looked down. A pause. I don't recall. Michael did not move. You filed this case alleging improper withdrawals. Did you review the nursing invoice before filing? I reviewed what I was given. That was not my question. Another pause. No, the first shift in the room was almost invisible. Just a slight change in air. A small weakening. Michael moved to the April reimbursement. Then the May pharmacy documentation. Then the home safety modifications. Each time, the pattern held. My father had selected the withdrawal, highlighted the amount, and omitted the corresponding expense or reimbursement notation. By the third example, the judge had started looking directly at the record instead of at the witness. Michael turned one page. Mr. Mercer, you also testified that Ms. Mercer was not regularly involved in care. Are you aware she was listed as the primary scheduling contact for overnight nursing on at least 6 occasions? I wasn't informed of every arrangement. No, Michael said evenly. That seems to be the issue. Pike objected to tone. Judge Holloway overruled him without much interest. Michael continued. Let's discuss the branch records. You requested selected banking materials after your wife's death, correct? Yes. Selected by you? Yes. And when you made that request, you did not ask for appointment notes, reimbursement forms, or supporting documentation submitted with the withdrawals, did you? My father's mouth tightened. I asked for the account records. Right, Michael said. You asked for the portion most useful to your theory. Pike objected again. Argumentative. This time the judge looked up. Sustained as to form, he said. Then, to Michael, rephrase. Michael did. When you requested records, did you request only the statements and signature materials? Yes. Thank you. He returned to counsel table, took the branch manager's statement from the binder, and approached the witness with permission. He handed it over. Please read the highlighted paragraph silently. My father read it. Even from where I sat, I could see the color shift slightly across his face. Michael waited until he looked up. Does that statement indicate that supporting invoices were presented for at least some of the challenged transactions? Yes. And that your wife discussed reimbursements in person with branch staff? A longer pause. Yes. The judge made a note. My father looked briefly toward Lauren, then away. Pike declined redirect. That told me more than anything he had said all morning. Then Lauren was called. She took the stand with a careful expression that might have read as sincerity if I had not seen her use it since she was 16. Pike led her through the expected points. She lived closer. She visited often. She took our mother to church when she was able. She believed I was busy with work and not really around for the hard parts. After our mother died, she said, she saw account activity she found upsetting. Michael stood for cross. Ms. Mercer, he said, did you ever review your mother's full financial records before her death? No. Did you schedule overnight care? No. Did you communicate with the neurology office regarding medications or falls? No. Did you review reimbursement forms submitted to the bank? No. He let each answer land cleanly. Then he asked, so when you testified that certain withdrawals appeared improper, that conclusion was not based on complete records, medical scheduling, or banking documentation. It was based on selected statements shown to you after your mother's death. Correct? Lauren's hands tightened around the edge of the witness stand. I suppose that's fair. He nodded. No further questions. The pastor testified briefly after that. He spoke about family devotion, community presence, and the burden of caregiving. He had known my parents for years. He had seen Lauren there often. He had not seen me as much. He said this gently, as though reluctant. The problem was that none of it touched the actual issue. He knew nothing about the accounts. Nothing about the invoices. Nothing about the reimbursements. Michael asked him 4 questions. He answered all 4 honestly. No, he had never reviewed the financial documents. No, he had not spoken with the bank. No, he was not involved in the medical coordination. No, he could not testify to whether any withdrawal was legitimate. That was enough. By then the room had changed. Not dramatically. Quietly. The story my father brought in had depended on atmosphere, community impressions, physical nearness, the appearance of devotion. But atmosphere weakens when paper starts getting read aloud. Then it was our turn. Michael did not call me first. He moved the branch manager's statement into evidence, then the nurse's statement, then the reimbursement list and supporting invoices. Pike objected to portions. Some objections were sustained. Most were overruled. None of that troubled Michael. He only needed enough admitted to establish sequence. Then he called me. I walked to the witness chair, sat down, and folded my hands once in my lap before placing them on the armrests. The wood felt cool and worn smooth at the edges. Michael's questions were simple. Did I advance funds for my mother's care? Yes. Did my mother reimburse me for some of those costs? Yes. Did I keep records at the time? Yes. Did I sign my mother's name on the challenged transactions? No. Did I conceal expenses from the family? No. Did I provide care coordination remotely and in person as needed? Yes. He handed me the letter from my mother. Do you recognize this document? Yes. How? It is in my mother's handwriting. And when did you receive it? In January, about 2 weeks before she died. Pike objected on foundation. Michael laid the foundation. The judge allowed limited use. I was shown the page with her instruction to counsel and the reimbursement list. Did your mother indicate that certain payments from her account were reimbursements to you for expenses advanced on her behalf? Yes. Did she also identify you as the person handling those arrangements? Yes. That was enough. Pike stood for cross-examination and tried, for a few minutes, to restore the earlier shape of things. He asked why more family members had not been copied on every payment. He asked why I had not insisted on group transparency if everything was legitimate. He asked whether distance had made misunderstandings inevitable. I answered each question the same way, calmly, narrowly, without filling silence for him. When he asked, wouldn't a more transparent daughter have shared all this in real time? I said a more curious father might have asked for the full records before filing. Michael objected before Pike could react. The judge allowed the answer to stand. That was the only moment in the hearing when my father looked directly at me with something close to open anger. Not because I had insulted him. I had not. Because I had refused the role he had prepared for me. I was not embarrassed. I was not pleading to be believed. I was defining the record. By the time testimony ended, the courtroom felt cooler than when we had entered. Or maybe I just felt steadier in it. Judge Holloway looked down at the exhibits for a long time before speaking. No one moved. No one shuffled papers. Even my father sat still. Then the judge removed his glasses, set them on the bench, and began to explain what the documents now showed. Judge Holloway spoke in the same even tone he had used all morning. That made what he said land harder. He began with the record, not with anyone's intentions, not with grief, not with the visible tension in the room. He walked through the exhibits one by one, summarizing what had actually been established. The challenged withdrawals were not standing alone. They were tied, in multiple instances, to invoices, care expenses, reimbursement notes, and branch documentation. There was no evidence that I had signed my mother's name improperly. There was no evidence that I had diverted funds for personal use. There was evidence, instead, of incomplete review and selective interpretation before filing. He paused there and looked down at the papers again. My father was sitting very still at counsel table, but I could see one thumb rubbing hard against the side of his index finger, over and over. Lauren kept her eyes fixed on a spot just above the floor. The judge continued. He said probate disputes were serious enough without being built on partial records. He said courts did not exist to ratify assumptions made in anger. He said family suspicion was not a substitute for documentation. Then he turned to the specific request before him. The petition would be denied. The allegations regarding improper withdrawals were not supported by the evidence presented. The request to freeze distribution based on misconduct would also be denied. He took a breath, glanced once toward Douglas Pike, and added that the manner in which the case had been prepared raised concerns about whether reasonable inquiry had been made before serious accusations were filed. He was not issuing sanctions from the bench at that moment, but he was allowing Michael to submit a fee petition within 10 days if we chose to do so. That was more than I had expected. Not because I doubted the documents. By then, I trusted the record. But courts are often conservative in how much they are willing to say beyond the narrow ruling. Judge Holloway was making it clear that this had not just failed. It had been handled poorly. Pike stood to say something about grief, confusion, and the emotional strain on surviving family members. The judge listened for about 15 seconds and then stopped him with a raised hand. I understand grief, he said. What I require is diligence. That ended it. He gave a few final procedural instructions. The clerk noted deadlines. The next matter on the docket was called. Just like that, the hearing that had occupied my mind for over a week became another item the court was already moving past. That is one of the stranger things about formal resolution. When you are inside it, it feels enormous. When the decision comes, the system treats it as exactly what it is. A matter decided. Papers to follow. Michael touched my sleeve lightly and nodded toward the aisle. We stood. Across the room, my father remained seated for a few seconds longer than everyone else, as if he needed time to understand what posture he was supposed to adopt now. He had arrived expecting recognition, maybe sympathy, certainly confirmation that his view of events deserved official weight. Instead, the court had reduced the whole thing to what it really was: a filing built on missing pages. Lauren stood beside the bench behind him, one hand still on her purse strap. She looked smaller somehow. Not younger, just smaller, as if the certainty she had borrowed from him no longer fit. I gathered my binder, capped my pen, and walked out with Michael into the hallway. The courthouse felt brighter than before, though the sky outside was still mostly white. A deputy passed us carrying a stack of folders. Somewhere farther down the corridor, a copier started up. I could smell coffee again from the vending alcove near the stairwell. Michael and I stepped aside near a window. Well, he said, that went about as well as it could have. I let out a slow breath. Yes, I said. It did. He glanced down at the fee issue in his notes. I'll prepare the petition unless you tell me not to. I thought about that for a moment. There had been a time, maybe 10 days earlier, when I might have said no. Not out of kindness. Out of exhaustion. Sometimes people decline the next step simply because they want the whole experience to stop making demands on them. But by then I understood something more clearly than I had at the beginning. Declining to pursue consequences is not always the same as being done. Sometimes it just leaves the administrative burden sitting with the wrong person. Yes, I said. File it. He nodded once, as though that answer had been likely. Then my father came into the hallway. Pike was half a step behind him, already speaking in a low voice about next steps, written orders, options. The kind of language attorneys use when the real outcome is already clear and the client needs structure more than hope. My father stopped a few feet away from us. For a second, no one said anything. He looked older than he had when I entered the courtroom. Not transformed. Just more visible in the ordinary way people become visible when confidence leaves them all at once. The skin at his jaw seemed looser. His tie sat slightly off-center. There was a pale line where his glasses had rested too tightly against the bridge of his nose. Claire, he said. I waited. He was not good at apology. Even at the best of times, he preferred revision to admission. He would retell something in a softer form and treat that as repair. This got out of hand, he said. I looked at him for a moment. No, I said. It was put in motion. His mouth tightened a little. That's not what I meant. I know. There was a silence after that. Not dramatic. Just clean. Lauren had come up beside him by then, but she still would not look at me directly. My father said, I was trying to protect your mother's estate. You were trying to protect your version of events. Pike shifted slightly, as if he would have preferred this conversation not continue within hearing range. Michael said nothing. That was one of the reasons he was good. My father looked past me toward the window, then back again. You could have explained all this earlier. I answered him carefully because by then I no longer needed him to understand in order to speak clearly. I explained what required explanation when Mom was alive. What you wanted was not information. You wanted visibility on your terms. He did not respond to that. He could not, really, without admitting more than he intended. Lauren finally spoke. I didn't know about all the records. Her voice was low, controlled, but not steady. I turned to her. You could have asked. She swallowed. Yes, she said. I could have. That was the closest thing to honesty I had heard from her in months. Not enough to repair anything, but real. My father tried once more, and this time I could hear the effort it cost him to keep his voice level. What happens now? That question had layers in it. The estate, the fee petition, the family, his reputation in town. The practical arrangements he had assumed would continue around him no matter what he filed. I answered only the part that belonged to me. Now the estate proceeds according to the documents and the law. He nodded once as if I had confirmed the existence of weather. Then I added, and I'm no longer handling anything informally. That was for both of them. No more quiet payments. No more stepping in without acknowledgement. No more administrative labor hidden behind family language. If something needed to be done, it would be requested properly, documented properly, and answered on terms that could survive daylight. Lauren looked at me then, finally. What does that mean? It means exactly what it sounds like. No anger. No speech. Just boundary. My father drew in a breath as though he might say something larger, something that would reframe the last week into a misunderstanding he could live with. But nothing useful came. Pike touched his elbow lightly, and that seemed to settle it. We'll be in touch through counsel, Pike said. Michael answered that would be best. And that was that. They walked away down the hallway together. My father first, still upright, still trying to resemble the man who entered the building certain of himself. Lauren a few steps behind. Pike already talking quietly again, probably about order language, deadlines, optics, all the practical terms that remain after certainty has failed. Michael and I stayed a moment longer. Then he asked, "Do you want lunch or do you want silence?" I thought about it. Silence, I said. Good answer. He handed me my copy of the notes, told me he would send the draft fee petition by the weekend, and headed for the stairs. I walked out to the parking lot alone. The air felt mild now, a little warmer than it had been that morning. Cars moved steadily along Main Street. Somewhere across the road, someone was trimming hedges with electric clippers. The sound rose and fell in neat mechanical bursts. I unlocked my car, set the binder on the passenger seat, and stood there with one hand on the door for a second before getting in. I did not start the engine right away. Instead, I opened the binder one last time and looked at the tab marked letter. My mother's handwriting sat there in black ink, unshowy and exact, having done what it needed to do. That was the part one kept coming back to. Not triumph. Not vindication as performance. Just the relief of seeing a record hold. I closed the binder, set it aside, and finally started the car. On the drive home, I stopped once at a garden center just off the highway. Not for anything urgent. I bought 2 small rosemary plants, a bag of potting soil, and a pair of plain terracotta pots I did not need but liked the look of. The woman at the register wrapped the plants loosely in brown paper. When I got home, I carried them to the back patio and set them on the outdoor table without unpacking the car right away. The afternoon was quiet. Damp boards underfoot. A light breeze moving the fence vines. Somewhere nearby, wind chimes knocked softly together. I stood there looking at the plants for a minute. Then I went inside, washed my hands, and set a kettle on the stove. The written order had not arrived yet. The fee petition was still ahead. There would be calls, paperwork, and likely 1 or 2 more attempts from family to rename what had happened. But the center of it was over. And for the first time in a long while, the house felt like it belonged entirely to the truth I could live with. That evening, I did not call anyone. I put the kettle on. I changed into a gray sweater and old cotton pants. I opened the back door to let in a little air while the water heated, and I stood at the sink rinsing dirt from the rosemary pots I had bought on the way home. The kitchen smelled faintly of wet clay, tea, and the clean green scent that rosemary leaves release when your fingers brush them. It was the first quiet evening I had had in weeks that did not feel temporary. I made tea in the blue mug I usually saved for weekends. I carried it outside to the patio, set it on the table, and repotted the 2 plants slowly, one at a time. Soil first. Then roots loosened gently at the base. Then more soil pressed down with both hands until each plant sat straight and steady in the new pot. I like small jobs that have a clear ending. When I finished, I lined the pots along the back step where they would get the morning light. Then I brushed the loose dirt from the table with my palm and went inside before the air got cold. Michael emailed me the draft fee petition just after 7. I read it once at the dining table, made one minor correction to a date, and sent it back. No speeches. No extra comments. Just confirmation. After that, I opened a drawer in the sideboard and took out a folder labeled estate. I removed the loose pages that no longer needed to sit on the table and filed them in order. Court notice, response, branch statement, caregiver invoices, my mother's letter, hearing notes, everything in one place. Then I put the folder in the cabinet and closed the door. That mattered more than I expected. Not because it erased anything. It didn't. My father still filed what he filed. Lauren still stood behind it until the documents made that difficult. The hearing still happened. The damage to trust was real, and I did not pretend otherwise. But order has its own kind of comfort. So does naming the end of a thing correctly. In the days that followed, I kept my routine. Work in the mornings. Walk after dinner if the weather held. Groceries on Saturday. Laundry on Sunday. I answered only the messages that needed answers. When my father called once and left a voicemail saying we should talk as a family, I did not return it. Michael had already filed the fee petition. Communication could go through counsel for a while. Lauren sent a text 3 days later asking whether there was any path back from this. I read it while standing in line at the pharmacy. Then I put the phone back in my bag and waited until I got home to answer. There is a path back from many things, but not all paths are immediate, and not all of them are relational in the way people hope. Sometimes the first path back is procedural. Correct the record. Follow the will. Stop improvising around the truth. Accept boundaries. Let time do its part without trying to rush everyone into language they have not earned yet. So I wrote back, for now, the path is simple. Respect the documents. Respect the boundaries. Don't ask for closeness when basic facts were treated as optional. She did not answer right away. A week later, the court approved a portion of the fee request. Again, no drama. Just an order. Amounts specified. Deadline set. My father would have to absorb the cost of what he started. Not in some theatrical way. Just in the ordinary way consequences arrive when they are tied to paper, dates, and a judge's signature. That felt right to me. Not satisfying. Right. A few days after that, I drove to my mother's grave with fresh white tulips and a small pair of pruning shears from my glove compartment. The cemetery was quiet, just a little wind moving through the bare branches at the edge of the property. I trimmed the spent stems from the previous arrangement, set down the tulips, and stood there with my coat buttoned all the way up against the breeze. I didn't say much. I never feel the need to perform emotion in places like that. I just told her the matter had been handled, that the record held, that I understood now, more than I used to, why she wrote things down when she did. Then I stood there another minute and listened to the trees. On the drive back, I thought about how often the real work in a family gets done by the person no one is properly looking at, the one making calls, keeping lists, noticing gaps, carrying the part of life that leaves no obvious monument behind it. People rarely admire that kind of work when it's happening. They usually notice it only when it stops. That thought stayed with me longer than the hearing itself.